What happened in Congress yesterday left Justice Brett Kavanaugh visibly unsettled and sent shockwaves through the legal world. In under 3 minutes, Representative Denzel Washington delivered a calm, surgical constitutional argument that redefined a routine oversight hearing. Kavanaugh, clearly annoyed, attempted to dismiss the congressman with, "These are complex matters requiring legal expertise." But Washington didn't react emotionally. He responded with clarity, not volume. What followed was less a rebuttal, more a masterclass in constitutional law. Kavanaugh had no answer, not with precedent, not with principle. If you're tired of seeing qualified black men dismissed, this moment wasn't just satisfying. It was historic. And what Washington said next didn't just silence Kavanaugh, it exposed deep inconsistencies in the court's First Amendment logic, a conversation legal scholars will debate for years. To understand the moment's weight, we need to understand the men involved. Justice Brett Kavanaugh, 59, has served since 2018, a Yale graduate and self-described textualist in the mold of Scalia. He champions executive power, religious liberty, and free speech, though critics point out his rulings often fall along ideological lines. Yesterday's hearing focused on recent First Amendment rulings, protests, campaign finance, religious rights. It wasn't meant to be controversial, but concerns have grown that the court applies its principles inconsistently, depending on who's speaking. Enter Denzel Washington, in his second term representing California's 43rd District, a veteran civil rights lawyer. Washington has argued voting rights cases and defended activists against powerful institutions. He doesn't rely on staff for case law, he lives it. What few knew was that Washington had spent 6 months quietly leading a legal review of the court's First Amendment rulings across 5 terms, collaborating with scholars from Yale, Stanford, and Howard. What emerged was a pattern no one had dared confront publicly. Until now, the hearing was already notable. It's rare for justices to appear before Congress, but as public trust in the court declines, Kavanaugh and 2 others appeared under pressure. Each lawmaker was allotted 5 minutes. Washington made his count. The room was packed. Kavanaugh had just finished an easy line of questioning when the chairman gave the floor to Washington. Dressed sharply, Washington calmly adjusted his binder, then addressed the room. "Justice Kavanaugh, I want to discuss something you've emphasized: constitutional consistency. In Americans for Prosperity v. Bonta, you wrote, 'Consistency is essential to the rule of law.' Do you still believe that?" Kavanaugh agreed. "Yes, absolutely." Washington opened his binder. "In Bonta, you said donor disclosure laws imposed enough of a burden to warrant strict scrutiny. Yet in McKesson v. Doe, a protest case, the court allowed organizers to be held liable under a lower standard. Why are similar First Amendment rights treated differently?" Kavanaugh replied, "They're different contexts." Washington stayed composed, but both involve freedom of association. In Bonta, it was donor disclosure. In McKesson, it was financial liability. Why does one get the court's highest protection while the other doesn't? The room went silent. Kavanaugh began to explain different facts, different governmental interests. Washington nodded. "But the principles, shouldn't they be the same? Isn't that what consistency demands?" He moved to another case. In Kennedy v. Bremerton, you upheld a coach's right to pray publicly. Yet in City of Austin v. Reagan, you allowed the government to restrict signs. Both were about expression versus speculative harm. Why protect one and not the other? Kavanaugh shifted. "These are complex legal issues." Washington didn't raise his voice. "Justice, I've spent 15 years in courtrooms defending constitutional rights. I've argued First Amendment cases before federal courts. I know what these principles mean in real life." No one spoke. Even the cameras seemed still. "This isn't about differing facts," he said. "It's about analysis changing based on the speaker or message." He tapped the screen. Side-by-side rulings appeared. Your court applied strict scrutiny to religious speech, but used a lesser standard for similar secular speech. The Constitution doesn't rank beliefs. It protects speech, period. He held up writings from Madison and early Supreme Court rulings. Nowhere does it say religion deserves more protection than labor or protest. He stepped forward. Yet here we are. Kavanaugh tried to respond. Congressman, the court aims for consistency. Washington cut in. Combat direct. I've reviewed 7 First Amendment cases in every one. Scrutiny levels aligned with ideology, not principle. Religious. Conservatives get strict scrutiny. Protesters and workers get rational basis. That's not legal reasoning. That's outcome shopping. He held up a chart to different constitutional standards depending only on who's speaking and what they're saying. Kavanaugh adjusted his tie, clearly uneasy. Congressman, he said, the court considers the facts. Every case is unique. Denzel nodded. Facts differ, sure, but the principles justice should be the same. That's your standard, not mine. Another click. More legal citations, this time from Madison and early precedent. Denzel wasn't just arguing. He was walking them through doctrine like someone who had practiced it for decades. You've built your legacy on neutrality and the Constitution's text, he continued. But these rulings show a pattern. Scrutiny doesn't follow law, it follows ideology. Kavanaugh tried again. Decisions must reflect the real world. We can't reduce the Constitution to formulas. I'm not reducing anything, Denzel said calmly. I'm highlighting contradictions using your own words. The room tensed. The First Amendment doesn't protect only convenient speech, Denzel said. It doesn't favor corporate belief while muting public protest. If we're going to defend the Constitution, we have to defend it equally for all. Phones went up. Reporters weren't chasing headlines. They were witnessing history. And here's the truth, Denzel said, steady. When courts shift their standards based on who's speaking, they aren't applying law. They're managing appearances. Kavanaugh, visibly unsettled, replied, You're merging separate doctrines to imply bias? I'm not merging anything, Denzel responded. I'm holding up your rulings. The inconsistencies speak for themselves. He stepped forward. In Americans for Prosperity, you said even small burdens on association must face strict scrutiny. But that same term in Cedar Point Nursery, you applied a lower standard to a more serious burden on labor organizing, also protected by the First Amendment. Same right, different treatment. His voice never rose. It didn't need to. And what about history? He added, in Kennedy, you ignored long-standing limits on religious expression in schools. But in Bonta, you leaned heavily on tradition. So which is it, justice? Does history matter or only for some? The committee chair tapped. His pen time was almost up. Denzel nodded, then turned back to Kavanaugh. Justice Kavanaugh, I respect the institution. I respect the robe. But I'm asking, what does it protect and who, when strict scrutiny favors one kind of speech and ignores another? The court doesn't just shake trust in its rulings. It shakes trust in justice. Kavanaugh didn't reply. His silence wasn't measured, it was stalled. The threat to First Amendment freedoms, Denzel said, eyes fixed, isn't government limits, it's the belief that your protection depends on who you are and what you say. No applause, no theatrics, just a moment that cut through. Members on both sides of the aisle nodded slowly. Even Republicans who came in combative now sat still, not out of agreement, but recognition. Kavanaugh sat frozen, the sharp confidence of his legal posture dulled by having his record read back, like a hymn out of tune. A senior GOP member whispered, to a Democrat, I don't agree with him, but that was a damn masterclass. Chairman Jordan finally broke the silence. The gentleman's time has expired, but the witness may respond. Kavanaugh gathered himself. The court applies constitutional principles consistently, though each case presents unique facts. I appreciate the congressman's preparation, but his reply missed the mark. He didn't address a single example. The man known for clarity had no answers, only generalities. As the hearing moved on, members quietly approached Denzel. No cameras, no posturing, just respect. A veteran congressman, once a D.C. circuit clerk, was overheard saying, Best constitutional analysis I've seen here into decades. Then the real wave hit. Within hours, clips of the exchange had gone viral, not sensational, viral, but substance viral. Hashtag constitutional class and hashtag Washington schools Kavanaugh trended nationwide. Over 30 million views in under a day. Harvard Law's Lawrence Tribe tweeted, "In 50 years, I've rarely seen a justice so thoroughly and respectfully challenged on jurisprudential consistency." Even conservative voices took note. Former Judge Michael Luttig wrote, "While I support many recent First Amendment rulings, Congressman Washington raises serious questions. His analysis deserves serious attention." News outlets shifted from reporting to dissecting. This wasn't about Denzel, it was about what he revealed. Real inconsistencies, ideological drift, and a credibility problem in the court. The next morning, the New York Times ran a front-page piece, a tale of two scrutinies, calling Denzel's remarks a rare moment of clarity. Legal scholars across the spectrum echoed his points, not rumors or opinions. But Patterns.CNN convened a First Amendment panel that night. Most weren't surprised by what Denzel had pointed out. They were surprised someone finally said it. "He didn't posture," said one conservative analyst. "He pointed out what's been obvious in the case law but never addressed in open session." Within a week, law schools requested permission to use the hearing in their curricula. Georgetown Law announced a symposium on scrutiny in First Amendment law, directly inspired by the exchange. Yale Law Journal commissioned a special issue. It wasn't just news anymore, it was doctrine. And inside the court, the temperature rose. Justice Kavanaugh, once dismissive, now found his rulings under formal review by scholars, by students, and by his peers. The Washington Post ran with it. Kavanaugh's First Amendment record under scrutiny. The analysis echoed Denzel's. Break down selective standards, outcome-driven logic. Blogs lit up. Scholars coined the term the Washington test, not a stunt, but a question of consistency. Does a justice apply the same scrutiny no matter who's speaking? One Harvard professor said, "This hearing changed how I teach judicial neutrality." Even inside the court, according to the New Yorker, justices admitted quietly that Denzel had surfaced something real. Some worried not just about the doctrine but about perception. If a congressman could chart the pattern so clearly, what did that mean for the court's legitimacy? This was no longer about a hearing. It was about change. Denzel Washington's performance had reshaped his public image not as a celebrity, but as a constitutional force. Law schools invited him to speak. The American Constitution Society asked him to keynote their national convention. The title, Neutral Principles and the Myth of Equal Speech. The National Bar Association even created a new award, the Denzel Washington Prize for Constitutional Integrity. The first recipient, a law student from Howard, said, "This proves the law lives through those willing to speak." But the most important change wasn't in awards or speeches, it was in Congress itself. Commentators began calling it the Washington model. Rigorous, respectful oversight grounded in law, not politics. 2 weeks later, Pew Research released a poll. 71% of Americans believed justices should explain inconsistencies in their reasoning. 64% supported rules for doctrinal transparency. The public had spoken. 3 months after the hearing, the court took up a new protest case under the First Amendment. The nation watched not for the lawyers, not even for the ruling, but to see if scrutiny would remain consistent. The courtroom was full. But what lingered wasn't noise. It was the memory of a voice, steady, precise, unafraid to ask, is justice still blind or is it just selective?